Did you know that in the state of Illinois, somebody can be charged with driving under the influence when they're not even driving? Weird, right? And people are thrown off by this all the time. Unfortunately, I see many people who are not even aware of the law and are not even aware that they could be charged with DUI in these circumstances, yet they are. And they're not happy about it, and obviously they wish they would have known this ahead of time. So that's the purpose of this video, is to explain to you what the law is when it comes to driving or being in actual physical control of a vehicle for purposes of getting charged with a DUI. So let's dive into that right now. Hi, I'm attorney Derek Martin with Driver Defense Team. Our law firm fights a few hundred DUIs every year here in the Chicagoland area and the suburbs. So we see this a lot, actually. You'd be surprised. If you fight a couple hundred DUIs every year, well, then you have a few dozen of them where this is a big issue. And so what we're talking about today is how you get charged with a DUI when you weren't even driving. Well, let's first turn to the law. The law says that a person shall not drive or be in actual physical control of the vehicle while under the influence of alcohol or drugs or whatever. But again, driving or in actual physical control. So let's break that down. Driving's pretty straightforward, right? When they pull you over, and that's not usually the issue. But in many cases, they don't pull you over right behind the wheel, right? Very common scenario, somebody is asleep inside their car. Maybe that car's pulled over in a parking lot. Person's sleeping it off, as they say. They can still be charged with the DUI. Other times there's an accident, right? Or maybe even just a one-car accident. Somebody blows out their tire and they're on the side of the road changing their own tire. They can still be charged with DUI. More things, I can think of a case that we have right now where they had driven into a ditch and literally they could not drive. They can't get the car out of the ditch, yet they're still charged with driving under the influence. So it's not necessary that the officer actually see you behind the wheel driving down the road to get a DUI. Instead, they have to show that you were in actual physical control. And so what does that actually mean? Well, as you can imagine, there is a lot of cases in Illinois like this. This has been argued all the way up to the Illinois Supreme Court level. And they have done their best, or made some effort, to define what it means to be in actual physical control of a vehicle. Now, these factors are considered on a case-by-case basis. So there is no exact rule that says, well, this is actual physical control and this one is not. Instead, there is a series of factors that determine, did you have the capacity or the potential to operate that vehicle? That's the question that they're trying to answer. Not were you actually driving, but could you have been driving that vehicle? And I don't mean like, could you have in the past been driving that vehicle? I mean, did you even have the capability, the wherewithal, the abilities to do that? What they look at is typically three different factors. One, were you in the driver's seat? Obviously, if you were in the driver's seat, it is much more likely that you were the person who was in actual physical control of the vehicle. But even if you weren't in the driver's seat, like the example I used earlier, I got a client who was outside of the vehicle changing the tire. Is that actual physical control? Well, they weren't in the driver's seat, so that is helpful for them, but that's not the only consideration. The other consideration is, where were the keys? Who had the keys to the ignition? Now, back in the day, you remember that you had to actually put the key in the ignition and crank it to start, right? That was a little more clear, right? Were the keys actually in that ignition, or were they in your pocket? Were they in the back seat? Were they in the trunk? Did you throw them off in the field somewhere, right? Everyone's heard that. That was a bigger issue. But these days, most people have a key fob, right? Where that key just needs to be within the vehicle somewhere. And then you can press the button to start. Foot on the brake, typically press the button to start. So the keys becomes a little bit bigger of a question mark then, right? What if the keys are under the passenger seat? Well, that person could probably still start the vehicle, right? Even if they're in the trunk or in the back seat, you could probably still start that vehicle. They could be in your pocket and you could still start that vehicle. So that is a different sort of consideration than it was back in the 90s when they first started laying out this law in detail. But nonetheless, that is still a consideration for the court when determining were you in actual physical control. And the last one is, are you physically able to start the car and move the vehicle? Now, even that can be tricky. Physically able to start the vehicle. Well, many times the vehicle's inoperable. People get in an accident, right? I have a case right now where my client says that his wife was driving. The wife was perfectly sober. And she was actually perfectly sober. And they say that she was driving. She ran off the road a little bit and went kind of down into a ditch, nothing too bad. They both got out. He was intoxicated by his own admission, but he was the passenger. He had the DD, right? His wife had chosen not to drink that night and get him home safely. Well, they got in this minor little single car accident where they drove into a ditch. They switched, right? Pushing, he's trying to get the car out, right? He literally cannot get the car out, but keys are there, the car's on, he's in the driver's seat, but the vehicle cannot even be moved, but he's trying. So that is that third factor, right? Were you physically able to start that engine? And you can think of scenarios where the engine won't turn on, and were you able to move the vehicle? None of those three are what we call controlling. They're all weighted, they're all sort of determined and weighted and to determine overall, can the court consider this to be actual physical control of the vehicle? Very, very case-by-case basis. This is where, having a lawyer who's familiar with this comes into play, right? Obviously, very, very helpful to have a lawyer who's familiar with the law. Another really, really important thing is that the person's intent to put the car in motion or not put the car in motion is not relevant to determine actual physical control. So I've got another case where a guy says he's drinking in the bar and runs out to his car to grab some things, but is going back into the bar. In fact, I have another case where he's doing that. Someone different is doing that. They're at the bar. They go back to the parking lot, but they're actually at the hotel bar. Interesting, right? They're staying in that hotel. He's got the receipt. He's proved it. He's already checked in. He's in that hotel. But he ran out to the car after drinking to get some things. For whatever reason, the police come up, stop him, everything ensues, and this person is charged with a DUI. It is, pardon my language, bullshit, right? I mean, if you're that person, that is brutal. I was doing the right thing. I was not driving my vehicle. I had absolutely no intent to drive my vehicle. In fact, I can probably prove that. Any reasonable person would believe that, I was just going out to grab my bag or I forgot something in the car. I'm literally staying in this hotel. That hurts. That really hurts if you've been charged with a DUI in that circumstance. But the law in Illinois does say that your intent or whether or not you actually were trying to drive has no bearing on this situation whatsoever. You can still be in actual physical control of the vehicle. Another thing that the law says is it doesn't really matter at all if you knew this part of the law. Right? So in other words, if you could say, well, I didn't realize that I could be in actual physical control if I had the keys and I was sleeping in the back seat. It doesn't matter if you knew it or not. As they say, that ignorance to the law is not a defense. In other words, not being aware of the law is not a legal defense. And finally, I think that I just want to touch on this because emotions run really heavy when someone is charged with DUI and they weren't even driving. They are very upset, and I understand why. It is a tough situation to have to defend yourself in court when you believe that you were doing the right thing by sleeping it off or just running out to the car or whatever it is. But I'm warning you, you have to, at some point, realize what the law is. And I'm not saying you did anything wrong. I'm saying you have to realize what exactly the law is as you move forward to fight this case. Because the tendency to say, well, I wasn't trying to drive, I wasn't trying to drive, I wasn't trying to drive, is not helpful. Like I just said, that is not part of the calculation here for actual physical control. And so you need to wrap your head around that, and your defense will actually become better if you start attacking the right things instead of just repeating the wrong things. Right? And so this comes from experience, handling many, many cases like this. So I just wanted to touch on that and provide you some guidance, whether we are your lawyers and we can help you or someone else, whatever. My point here is to help you, put your best foot forward if you have not been charged with this, or if you have, to approach it the right way. Because I really do wish you the best of luck in your defense, and thank you for watching this video.